If a federal employee uses their government authority to deliberately and maliciously sabotage a citizen, can the government evade all liability based entirely on the placement of a single adjective? By default, the United States operates behind an absolute barrier known as sovereign immunity. You cannot sue the federal government without its consent. For over a century, citizens injured by federal workers had no legal recourse. That changed in 1946 when Congress passed the Federal Tort Claims Act, or FTCA. The FTCA acts as a limited waiver of that immunity. It establishes a general rule allowing citizens to sue the United States for property damage or personal injury caused by the negligent or wrongful act or omission of a federal employee acting within the scope of their job. To protect vital, high-volume government functions from a crushing wave of endless litigation, Congress carved out specific exceptions to this waiver. If your claim falls into one of these cutouts, the government's immunity remains fully intact. One of these is the postal exception, found in Section 2680B. The Supreme Court recently had to decide exactly how far this exception stretches. The FTCA lowers the government's shield to allow citizens to seek justice, but exceptions like this snap the shield violently back into place. The dispute in U.S. Postal Service v. Konan centers on precisely where that boundary lies. Labine Konan owns rental properties in Euless, Texas. In 2020, her local postal carrier stopped delivering mail to her buildings, eventually returning important mail addressed to her and her tenants back to the senders as undeliverable. Konan alleged this was not an accident. According to her complaint, the postal workers intentionally and maliciously withheld her mail, motivated by racial animus because she was a black landlord leasing to white tenants. The prolonged lack of mail delivery caused severe financial damage. Konan lost existing tenants, struggled to attract new ones, and paid for private carriers to handle her correspondence. She sued the United States in federal court under the FTCA, seeking damages for conversion and tortious interference, claims built entirely on the premise that the workers acted with deliberate malice. Her lawsuit hit a statutory roadblock. The postal exception blocks any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The lower courts split on how to read this. The Fifth Circuit Court of Appeals ruled in Konan's favor, determining that those three specific terms do not cover the intentional act of refusing to deliver the mail. The Supreme Court took the case to answer a highly specific question. Does a 1946 law grant the government immunity for deliberate sabotage based entirely on the interpretation of three overlapping nouns and one adjective? Writing for a 5-4 majority, Justice Clarence Thomas approaches the case through historical textualism. This method dictates that statutory terms must be interpreted according to their ordinary meaning at the exact time they were enacted, in this case, 1946. The majority executes a crucial analytical pivot. They conclude that the words in the postal exception describe the harm experienced by the plaintiff, not the behavior of the postal worker. Under this lens, the employee's specific intent is legally irrelevant. Thomas analyzes historical definitions of miscarriage and loss. In 1927 and 1934 dictionaries, miscarriage is any failure to reach its destination. 1893 and 1911 newspapers described stolen or burned mail as having miscarried. The 1946 Oxford Dictionary defines loss as suffering deprivation, regardless of cause. The context of the 1940s postal system supports this. Military reports and local newspapers from the era frequently used the word loss to describe mail that was actively stolen by actual postal carriers. Applying these definitions to Labine Konan, the facts are straightforward. Her mail failed to arrive, so it qualifies as a miscarriage. She was deprived of her mail, meaning she suffered a loss. Both trigger the government's liability shield. The majority's logic is entirely mechanical. If you apply historical textualism, the failure of mail to arrive is a miscarriage or a loss by definition. The postal worker's underlying malice becomes legally invisible. Justice Sonia Sotomayor authors the dissent.
She rejects the mechanical dictionary approach, relying instead on structuralism, reading the text in the broader context of the entire statute. Sotomayor executes an opposing analytical pivot, arguing the postal exception must describe government misconduct, not harm to the plaintiff. Through this lens, loss requires an unintentional parting. No ordinary speaker says they lost their keys if intentionally thrown into a river. She attacks the majority's reading of miscarriage, arguing their historical newspaper clippings are anecdotal outliers. In normal usage, she points out, describing a delivery as a miscarriage strongly implies an accident or negligence, not deliberate sabotage. Her structural argument focuses on the rest of the FTCA. Other immunity exceptions in the Act, like those for tax collection or Treasury operations, explicitly focus on the specific actions and duties of government officials, not the abstract harm suffered by the citizen.
Because the FTCA's general waiver explicitly permits lawsuits over wrongful acts, Sotomayor argues the postal exception must be read narrowly. Expanding it to cover intentional torts threatens to consume the exact rights Congress intended to grant. Sotomayor's core thesis is clear. Loss and miscarriage implicitly require inadvertent errors. Weaponizing the mail system to harass a landlord is an unprotected, intentional tort that the government must answer for. This philosophical divide over harm versus misconduct ultimately collides over the most granular linguistic debate in the case, the exact placement of the adjective negligent. The statute immunizes claims arising out of the loss, miscarriage, or negligent transmission of mail. For Sotomayor, Congress's specific inclusion of the word negligent proves they knew exactly how to exclude intentional acts from the immunity shield. If Congress wanted to immunize intentional acts, the negligent modifier is completely moot. Thomas counters using the rule of the last antecedent. An adjective placed before the final noun cannot be transplanted backward to qualify preceding nouns. According to the majority, negligent exists solely to limit the word transmission, preventing citizens from suing when perfectly transported mail is simply delayed. Grammatically, it has no power to alter the meaning of loss or miscarriage. This grammatical standoff demonstrates how textualists and structuralists can examine the exact same comma and adjective, yet construct two completely incompatible legal realities. Sotomayor's critique invokes the Konan against surplusage, a foundational legal presumption that legislatures do not use redundant, meaningless words when drafting a statute. If miscarriage broadly means any failure to arrive, then every single instance of negligent transmission is already covered by the word miscarriage. The dissent argues this creates massive statutory redundancy. Thomas acknowledges the redundancy, but establishes a strict hierarchy of interpretation. The Konan against surplusage is entirely subordinate to the plain historical meaning of the text. He points out the practical reality of legislative drafting. Congress frequently uses broad, overlapping terms, a belt and suspenders approach, to guarantee that liability loopholes remain permanently closed. The overlapping words aren't a mistake. They are a feature designed to build an impenetrable barrier against lawsuits. When historical text and structural efficiency conflict, the modern Supreme Court will prioritize the historical text, even if it requires embracing a highly repetitive statute. The Supreme Court holds that the intentional, malicious non-delivery of mail legally qualifies as a loss or miscarriage under the FTCA. The practical result is final. The U.S. Postal Service retains its sovereign immunity, and Lebanese Konan's lawsuit is permanently barred. The massive divergence in the 5-4 vote was dictated entirely by the initial analytical baseline. Once the majority decided the statute described a harm rather than a misconduct, Konan's case was over. The exact same words in the exact same law yielded completely opposite outcomes, depending entirely on the interpretive methodology applied by the judge. In modern appellate practice, having the right facts is rarely enough. Winning a case requires successfully defining the interpretive lens through which